Hello, and thank you for joining us for Best Practices for Developing Reliable Freedom to Operate Landscapes and Advanced Techniques for Interactive Reusable FTO Mapping. This is the fifth episode of an 8-part series about patent analytics. A recording of the webinar and the slides will be emailed to all registrants. Please feel free to enter any questions using the Q&A feature in the Zoom menu. And with that, I'll hand things over to Steve.
Great. Thank you, Michelle, and welcome everyone to episode 5 in the ongoing saga of analytics, etc. Today, we're very fortunate to have a great panel. Sunil Arora is joining us for the first time today. Sunil, former engineer in the medical device area, has been a partner at Schwegman for many years and has done a large number of webinars, or not webinars, but Freedom to Operate, also webinars too, but Freedom to Operate studies over the years. So he's a real expert in the area. Tyler, same thing, former chief patent counsel at Guidant Corporation / BSC. Tyler is also a partner at the firm and also has done a lot of FTOs, both in medtech and other areas. And Mark Stignani's back with us again. Mark's our analytics chair, and Mark does a lot of FTO work as well. So we've got a really strong group today. And with that, let's flip to the next slide. So everybody on this call probably knows what a freedom to operate analysis is, but sometimes they're called clearance studies or clearance opinions. And essentially what we are talking about today is the practice of making sure your product or service is free of infringement of third-party patents or free of potential patents that might issue from pending applications. So go on to the next slide. So today we're going to talk about, who uses the FTO studies, why they use them, when they're most useful, what kind of insights you might get from them. We've got special techniques we're going to talk to you about on how to make your FTO an evergreen FTO. We're going to talk about how those FTOs and mappings are generated for our proprietary technique, and then we'll maybe talk about some other tools that are out there as well. Next slide, Michelle. So, the basic question answered today is, will my new product or service infringe an issued patent, and will it possibly infringe a pending application when it issues? And we all know the typical use cases are new product development. We're going to make a new product, we want to make sure it doesn't infringe any third-party patents, or we got a new feature on an existing product that we want to release. Many times, if we're going to acquire a new company, we may look at whether or not their products are free and clear of third-party patents, so we don't buy into a lawsuit without some forewarning anyways. And then also, we sometimes do them to clear investments into startups that may be looking to get into an area, and we want to make sure we're not putting money into a potential lawsuit down the road. So those are typical use cases. Next slide. So, what are the benefits of FTO? We'll kind of be discussing these throughout today, but really, we avoid unnecessary infringement suits and allegations. That's usually the primary motivator people think about, but another reason to do FTOs is to align the development of a new product or a new feature with open IP space. In other words, if you've got options that you can choose from, better to choose options that both avoid third-party patents and provide you some ability to patent your own IP. Clearly, the closer you get to third-party technology that may be patented, the less patentable your technology sometimes is, because the prior art, if you will, of that prior technology is close. And then, of course, this helps us develop more patentable technology. And then Other benefits include being able to identify possible patents that maybe you could acquire to improve your position, or just get rid of them as a risk threat in the future, or just opportunities for companies that you may want to partner with that seem to have strong IP or buy things from. So there's a lot of benefits to IPO or FTOs rather that go beyond just simply avoiding infringement. Next slide, please.
Hey, Steve, I had just one comment on the
Yeah.
sort of the overall thing. Kind of as I sort of look at the FTO, one big FTO benefit is the ability to sort of understand risk and then mitigate risk. It sort of falls with your first, that first bullet point there. And then especially for in-house practitioners, the ability to talk to the management teams about what that risk looks like. And of course, if you're mitigating risk, that can, for smaller companies, that can certainly improve their value for potential, as a potential acquisition as well.
And from my standpoint, there's another benefit that's it lays the groundwork for companies to get to an assertion quicker. If you understand your FTO space, then you have a fairly good understanding of where you're free to exploit as well your new IP or that such as it gets in the marketplace. So you can kind of watch your developing competition creep up on you by keeping an open FTO on a particular product line.
Sunil, did you have anything, or you want to just?
Yeah, I would just add that, in terms of for startups who are looking for investment, what I've noticed over the years that I've been practicing is that the venture capital people and the investors have become a lot more patent savvy. So it's basically a checkbox on everybody's diligence list. And so if you've done that as a startup, it really helps advance the conversation when the investment rounds are being discussed.
Thanks, Sunil. That sort of jogs a thought that I have too, which relates directly to what you just said, Sunil, which is if you're a startup and you go to the investors and they ask you if you've done an FTO and you say no, they immediately think, okay, these folks may not know what they're doing. If you say, yes, I've done one, and it's not an issue, and I had somebody work on it with me that is recognizable, or not even recognizable, they immediately go, okay, well, at least they're doing their homework. So I think just the mere act of doing something, even if it's minimal, is going to get you more confidence of a potential investor than doing nothing, which basically raises red flags. So with that, let's go through the fundamentals. We'll start with the first question, and I'll have each panelist weigh in on these. So, is it feasible or even necessary to do an FTO? And maybe I'll turn it over to you, Tyler, and maybe you want to talk about some points on that.
Yeah, I mean, in my view, what I normally look at when starting an FTO is focusing on the key features of the product, and importantly, looking at which features may be prominently marketed that are new, which features are difficult or impossible to change, and focus any FTO work on those. So that sort of gets at the incremental improvements. If the incremental improvements really don't get after key features, it may not be worth doing an FTO at that point in time. And at the same time, if you've got a really complex product, you can often sort of omit FTO work or reduce the amount of FTO work on sort of commodity components or components you can change design with ease. So there's really less risk with those. So that's sort of how I, in terms of whether it's necessary or feasible or different ways to attack it, that's a little bit of what I keep in mind when starting off.
Sunil, any thoughts on that? Or Mark?
Yeah, So this is Sunil. Would just add that there are all sorts of different reasons for doing an FTO, including mitigating litigation risk. I think that when you talk to people on the business side, people are really concerned about the sunk R&D costs and the costs of having to do sort of a late design around late into their R&D process and the difficulty of doing that. And so, where it is feasible, it's probably a good idea to do that. There are just different levels of investigation and analysis that you can do. And oftentimes what we do is we try to, we try to define the FTO appropriately so that, as Tyler said, you're focusing on what really has a lot of importance. But, there are other things we can do too in terms of, for certain maybe lower priority features, we could actually look for expired patents or non-patent literature that would give us some degree of comfort level that there's a low risk of anybody having a valid patent that would be practicing those sorts of concepts.
And Mark here, just kind of adding my, bits and pieces here. I tend to go at it from a top-down and a bottom-up approach. Definitely features, especially if it's an existing product line, will take a lot of prominence in FTO work. But you try to break your FTOs into bite-sized pieces. So from the bottom up, you look at clearing interfaces, inputs, outputs, any feedback mechanics, any other easily discoverable aspects of a new product. So things that you're going to see upon launch that somebody's going to, a competitor or an NP is going to look at and say, hey, I've got something that covers that. Then from the top down, you want to look at systemic matters that probably commonly exist in the marketplace, and you clear those lightly. But then you also keep track of who's litigating in this space and who are the usual suspects who are competing with you, and maybe scrub them a bit harder. So I try to approach from both top and bottom when I'm trying to break a complex FTO apart.
I think everybody on this second point there, scope, everyone's kind of touched on this, or discussed it already, which is, you've got maybe a very complicated device and you're actually purchasing parts that you're going to be assembling together, in your assembly process. And do you need to clear every last part? Of course not, because that's almost impossible to do. You have to typically you got to take for granted that your supplier is doing their clearance of their particular subcomponent, and that they're going to cover you for any liability associated with that, and that your level of inquiry typically is going to be at the level that you're assembling the components together and creating your combination. So, but there's obviously, that's just kind of the general rule. So that's on that second point. I think timing wise, we can talk about that a little bit because that's a really key one. Sunil already mentioned that, last thing one thing you want to avoid is have a design all ready to go and then you do an FTO and you've got to redesign it. So maybe you could touch on that, panel members, on timing.
Well, I'll jump in here because I did a very long-term FTO when I was over at Thompson around one of the new versions of Westlaw, and we literally started 3 years before the product was to go live, and so we began clearing with the design team and the R&D team, so we were able to give them essentially clearance in the step-by-step process where they asked, can we do this? We had a chart that we could review and say yeah or no, and go into that. So my bias is the easiest FTO I've ever done has what happened 3 years before we did a product launch, because we were able then to avoid literally anything that we saw as a problem and design around it as early as possible.
So I'll just add, both Sunil and Mark touched on this. The key is not to do it too late, because if you do it too late, you really end up just relying on legal arguments as to why you may or may not infringe or why a patent may be invalid. If you can do it earlier, you get a chance to mitigate by changing the design of the product. And the key really is, oftentimes it's sort of to find the sweet spot where the specification for the product is well defined, yet development it still has room to change. And that way you're not sort of reviewing patents that may not be relevant because your spec changes, and you still have time to implement changes to the product if desired. The other, just one point I'll make on the timing piece, what I found really helpful in-house is building checkpoints into a product development plan, so that, all it really has to do is say something like talk to legal about patents and pick the right time for that to be part of the product development plan, or a check mark that the team needs to handle, and then they can come to the legal group. They can talk about maybe patents they want to cover their product, but you can also begin the conversation about when to do the FTO work at what time.
Thanks, Tyler.
Yeah.
Well, do you have comments? Yeah.
Yeah, I don't think I have anything to add. I think Tyler basically mentioned, the point that companies typically have their own processes for product development. And if you can bake into those processes, the different stages of the FTO, that's a good way to make sure that things happen at the appropriate times.
So thanks. The last point on here, really, we've sort of hit around too, which is defining the product for clearance. I've seen this done a few different ways. I mean, in some cases, I've seen the product development team just come up with a list of key features that they want to include in their product or new product enhancement. And then we kind of go out and do the FTO search around those features at that level. And then sometimes it's a more detailed spec. Are there any last thoughts on that from the panel?
Yeah, just, if you were embedded in the design process with your team, and a lot of in-house counsel are generally not, but if you're in-house and you can embed yourself in the proposed product, then you can get your FTO work started earlier than you can because, where I used to work, a lot of times you get the call, hey, we're going to the market in a couple of weeks, and could you tell us where this is clear to go? And those are painful discussions. But yeah,
Steve, I just tap into one of Mark's comments earlier about breaking the FTOs into sort of discrete chunks. But I've seen it numerous times where a client comes and they want to clear some new features in a product, and it's sort of based on an underlying platform, and that platform has never been cleared. And so you might get asked, well, should we clear everything, including the new features? Usually what we end up doing is focusing on the new features and then perhaps doing a clearance of the platform in a separate work stream. Because what you find is the folks that are doing the development on the new features will find it, rightfully so, pretty unfair that their project might get delayed to clear a platform that was developed well before they got involved.
And one last comment on the fundamental side, though. Make sure if you have a licensing department, make sure you involve them in discussing, because if your licensing team is going to be expected to somehow take this product out and sell it with the IP, at least get their thoughts and opportunities in mind as you're clearing as well.
One final comment for me that relates to these two different points in terms of the depth of design, and this is from just a very practical standpoint. Make sure you have the right people in the room that you're talking to. So under the first bullet point, if the design isn't final, then it's probably somebody from the new product planning team that needs to be involved in the discussion that's actually defining features. If you do have a design that's been implemented, then you need to make sure that that designer is actually there in the room and not just the new product planning person, because you need to understand whether the design is actually deviated and how it's deviated from the actual features as they were specified. So getting an accurate description, an accurate technical description of what you have available, whether it's at the feature level or the actual implementation level, the accuracy and completeness of that is crucial to getting a good result and keeping the costs down.
Thanks, Sunil. Next slide, Michelle. All right, so we've talked about, some of the fundamentals. This is more nuances in terms of what you may look at when you're doing your searching. Talked about kind of what we want to search for in terms of product features. So, there's many different ways you can slice the salami when it comes to what type of, what sort of set of data you want to look at. Most of the time we do US only FTOs, and then kind of go from that, branch that off if we need to into potential foreign equivalent patents that we might locate. But for medical products, for example, Europe typically is very important. So I'll let Tyler and Sunil speak to that, but that's sort of one point there. And then, you can cut it up by, whether you want to look at all competitors, only aggressive competitors. Maybe some of your competitors are giant companies that are known to never really enforce their patents. So, maybe it's not worth the effort to spend time clearing patents that are highly unlikely to ever be asserted. The answer to that depends on, the company's level of, risk tolerance. Maybe you need to look hard at NPEs, AKA trolls, to make sure that the people most likely to sue, are taken out of the equation before you design your product. Or you can look at everything. But anyways, I'll turn it over to the panel to comment on that. Mark, you want to go first? Okay.
Oh, go ahead, Mark.
We got Tyler. Okay, go ahead, Tyler.
Oh, okay. Yeah. So I think Steve was right on with regard to the medical device area. Normally we'd look at U.S. and then certainly look at counterparts outside of the U.S. Lots of times we'll also do English language. So this might pick up patents that may not be counterparts, but just do searching across the English language as well. I would say in most cases, we always get a list of assignees or potential competitors and run a search against them. In terms of whether to how deeply to look at a particular patent, then the question as to whether it's an aggressive competitor would come into play. But in terms of just identifying patents up front, we probably look more broadly at other just generally competitors in that space.
And just adding, when I get this, I generally try to ask the salespeople and marketing people of the client, and where are you going to sell this? Because that, in many cases, will define the scope of inquiry. Another expansion aspect is that if you get a problematic patent in the U.S., one of my first suggestions in FTO is to look at the family members, especially in Europe, where they may have been narrowed more significantly. So you can start to look for another defensive position if a claim is construed much more narrowly in Europe versus a U.S. matter, then you have another piece of information to give your client. Sunil?
Yeah, I would just say that, sometimes on the medical device side, sometimes products get introduced first in Europe. And so I think that changes the equation a little bit for the medical device companies. But I think that even the European medical device companies really tend to focus on looking at the US, because in most cases, there is a US counterpart. So if you're going to focus on one jurisdiction, the US is a great place to start.
So I think that, the pros and cons are obvious to some degree, but, I think mainly with pros and cons, it all has to do with cost and efficiency and time. So, I mean, if you can find a way to narrow the scope of inquiry without greatly increasing your risk, easier to get the job done faster, and not waste time. You know, one thing that I often say to new lawyers, and certainly talk to clients about once in a while, is like the one thing that a seasoned attorney can do for you is tell you what not to waste your time on. Whereas, you know, if you're brand new in the business, you tend to do everything like it's a law school exam, which is cover every base, no matter how many pages you need to put your answer down. And I think in the area of freedom to operate, that's extremely helpful, is to have someone that knows what not to waste time doing, because you can rack up some serious charges if you start spinning your wheels, or as Mark likes to say, start boiling the ocean, because there's a lot of stuff you can look at that just isn't going to be beneficial. It's just wasted money, and Lord knows corporations hate wasting money, as we all do. So next slide. So Mark, I'll kind of let you walk through this, but before you get started, I would just say at high level, the way that I've seen many of the FTOs sort of progress is, you know, you start out with trying to find a seed. You find the best reference you can, or best potential prior art, or not necessarily prior art, but patent you may need to worry about, and then kind of build on that and go out from there by improving your keyword searches to keep, and then you get your forward and backward citations, which Mark will explain can be used to take the seeds that you have and find connections to other patents that maybe don't come through keyword searching very well, until you end up with this big bucket of patents that you're going to need to do something with. But Mark, why don't you walk through that a little bit?
Sure. Well, and in all these technology techniques that are up here on the screen are, you know, very relevant in finding good art. One of the places I try to start, though, I try to treat art searching as very much like a sales funnel. If you've seen the Salesforce sales funnel, I'm trying to find everything that might be relevant, so that we don't miss anything, you know, even that would be a marginal there. And then what I like to do is I like to take tools for text analyzing and rip them apart and kind of find all the, you know, the noun phrases that are somewhat interesting, at least there, and I try to figure out synonyms as I'm going through that. So as I'm going through that, I can either use a semantic tool to do that work for me, or else I find it much more accurate to spend a little time educating yourself on the glossary of terms used in that particular art. So you can pivot around competitors, you can pivot around classification codes. You know, a lot of the, you know, FTOs, especially if you're looking for, you know, really fast-moving technology in the software arts and that sort of stuff, you may want to only look at the last 5-6 years, because you may miss something, you know, that is big in there, but that's going to be picked up if you're looking at kind of, is there something highly cited or has caused any number of rejections in this art space. I mean, we've covered a lot of this in our previous webinars here, so I won't reiterate on that, but it's an iterative process. So, and I really highly recommend working with the technology team, having the people who are most knowledgeable about this type of technology engage with you and say, yeah, that's a good word, that's not a good word, but nobody uses that word, and with the rest of us use. So you come up with a thesaurus of, you know, terms that are best used, and you use those. You know, I tend to like fuzzy logic or weighted searches, just because they'll bring things in that a pure Boolean won't bring in, but it brings in a bit more information than a lot of people like. So if you want to use Boolean, be a Boolean person, and that will give you a very terse search result, but then take your best results there and run a semantic to make sure you haven't missed something that has a different word set than you're using. So there's a ton of different tools out there. I try to use every one of them that I can get my hands on, because they all do something better than the next tool. But again, I find a lot of my expertise resides in the technologists that you're working with as a client. They are, in many cases, a lot smarter about what is not maybe patented, but is out in the market. And they can drive you towards the marketing brochures and things that you would also want to harvest as you're thinking about your searches. So I'll step down there for a second, and panel, do you have any other best practices that you'd like to use?
So Neil, you want
Mark,
to?
and I mean, just
Sorry, go ahead.
no, I was just going to add on the iterative part. I mean, lots of times what you find is you'll do some searching, and then you'll run forward backwards citations, and you'll pick up some stuff that you didn't catch doing keyword, and you can ask yourself, why wasn't it caught, and then iterate based on new keywords. And sometimes you find words that are commonplace now weren't used to describe the technology in the past as much. Take, for instance, mobile phone. Mobile phones used almost all the time now in patents that deal with that type of technology. But if you go back a ways, you may find cellular phone, or you may find mobile portable device, or portable terminal. So it is important to do the iteration like Mark suggested.
Because words do change, as just mentioned there. I mean, looking back at the word IoT now is a buzzword everybody loves to toss around, but prior to IoT being a thing, web-enabled or web-connected or web or internet connected, wirelessly connected, all those things would then read on IoT. So and then the word in air quotes smart devices also has a tendency to go back in time. When we went back in the early 2000s, have intelligent agents. So anyway, I can give examples for everyone. I'll stop for the brevity, but go ahead.
The only thing I would add to this is that it's great if you have somebody that's well versed both in searching and in the technology, and that's not always easy to find. We have people that are really good at searching or really deep into the technology. But if you can find somebody with both of those skill sets, that's the person that you want doing this sort of thing.
Yeah, and I'll add just a quick sort of reference to an FTO I did once, which was a classic example of terminology switching or changing. Did an FTO and got quite a few results, did even some forward backward, got a bunch of results, winnowed them all down, and I thought, well, we should probably do one more forward backward just to make sure. And sure enough, on the last forward backward, found the best, or the worst patent to deal with. And it really had no terms in it that you would ever expect. So it can be, those forward backward searches can be very, very helpful. So there's one quick question here I'll throw out just to sort of have a little interlude to this that came in, and it said, like, how important is it to review trade dress? And does anyone have any comments on that vis-a-vis design patents or final, product, I guess visual design elements of a product?
Well, I can take a whack at that, because if you're lucky enough to have an integrated design team that actually thinks about branding and look there, and you have an in-house counsel who looks at IP holistically, so they would cover trademarks, design patents, design, industrial designs, and you're going through a global aspect. Yeah, it can be very important, but it's, as far as a pure patent FTO, most of what we look at in FTO are utility matters. I've only done a couple FTOs on design patents, and it largely revolved around, putting pictures on PowerPoint and saying this looks most like that. So, there is a great opportunity if you have an integrated group that handles brand and designs and utility patents, that certainly would be an important thing to think about the FTO process, but in my experience, it's rarely done.
Yeah, and I think in a way that the FTO process for a consumer-facing product that has a lot of brand elements to it, packaging, or the actual shape of the product, or maybe even some sort of ornamental design, that's kind of flips more onto the trademark side of things, and sort of more of a trademark clearance issue typically. So
Right.
we're not really speaking to that much today. So we'll go to the next slide here and keep it rolling. So what anyone that's ever done an FTO, or done a number of them, because you may not have got it the first time, but usually you end up with a lot of patents that come through on these searches that you do that meet your search criteria or are forward and backward citations that pull into the pot. You end up with this big pot full of patents, if you will, that many of which, almost 90% of them, are completely irrelevant. And that's just the nature of keyword searching typically, because a patent will mention many things in it that have nothing to do with what's being claimed. If you search, pacemaker, you're going to get zillions of patents that maybe aren't even pacemaker patents. They're just talking about some medical treatment where they use a pacemaker. So there's lots of irrelevant stuff. So what do you do when you get that? How do you get rid of all those irrelevant things so you can focus on, what to do with it? And, I'll just say, typically there really isn't any way that, at least I'm aware of, that you could do that without eyeballs on to look at the actual claim, or even just the title of the patent. A lot of times is enough to look at to tell you that this is not relevant. And you go through and you maybe doing as many as 60 an hour, you get rid of all the ones that are just so far out of the realm of relevant that you don't need to worry about them. And I like to say that, when you do an FTO study, a lot of times what you're doing is you're trying to find something, that's the equivalent of, about a 5-foot diameter circle. But what, within that circle, but what you're getting stuff that's a mile away from that center of that circle. It's really easy to get rid of everything that's well away from the center of that circle. They're very easy to dismiss. And then once you're done with that, you end up with a number where you got to look at it more carefully. So maybe you start out with a typical one that we've done. You might end up with 3,000, 4,000, 5,000 patents that you need to get through, because they all have some keyword relevance, or they're some other reason you think they're relevant. And then you just have to put the time in to throw out all the ones that are just completely irrelevant. And then you get down to maybe 500 or something where you maybe need to look a little bit more carefully. But again, those ones go very quickly. And usually these things boil down to a couple hundred patents. If you're getting more than that on any given feature of a product, you're probably got way too many, because at the end of the day, it always kind of reduces down to a certain number of patents. It's not that many, because in the way that things work in the patent system is that the earliest inventions get the claims that you need to worry about, and the ones that follow on even 2, 3, 4 years later have narrower and narrower claims that just are more and more irrelevant to any given design goal. So with that, I'll turn it over to Mark or anybody else that wants to comment on filtering the first cut.
Well, what I like to do is in the first cut is, this is where you get your technical team in play. And my favorite review formats are, use a spreadsheet and, put the filters on the spreadsheet and just find what to throw away as fast as you can. You can do the same thing in a dashboard or a database that tool that has all these there. But I mean, just quickly reviewing classification codes. If there's something in a wildly different classification code, you may be able to eliminate a large number of patents immediately if you just look at the obscure class code. But generally it's just looking at title, abstract, and first claim, and maybe the first picture if you can get that stuck into your spreadsheet. That's really my favorite way of getting through. And I've had many clients where we've gone from thousands to 30 just in that first cut. Anybody else?
I don't have anything to add to that.
Okay.
No, I don't either. That's pretty typical to be able to cut it through pretty fast on the first cut.
Yeah.
So then we'll move on and we'll kind of pick up the pace here to get this. So, we've sort of gotten through the pile. We've got it down to, maybe we've got it down to as few as 30 patents, 50, maybe 100, sometimes maybe even 200, but it's usually somewhere under 200 that you really care about. And the typical way then, once you get this number of patents that you think are relevant, is the old-fashioned way, if you will, is, we used to just print them all out and kind of go into a room with the design team and put them in a stack, and we would just take them one at a time and look at them together. And they would say, nah, we're not interested in that idea. We're not going to use it. And it would go into the don't care pile. And then, oh, that one's kind of close. Put that aside. Oh, that one, that's really close. Put that in a different pile. You go through all these, and then you end up with the piles that, look at closely, look at a little bit more, ignore. And that works okay. But it's pretty inefficient. It's inefficient for, a couple of reasons. I mean, one is that when you force an engineer or a design team person to actually have to read each claim, independent claim anyways, and kind of tease out what's actually claimed in there, that can be draining. I mean, it's difficult enough for a trained patent attorney, but it's really dreaded for, engineering personnel. So that's inefficient. It's also uncomfortable, and no one wants to do it. Then if you change your design and have to go do that a whole nother time from scratch because you don't know one you threw out was now relevant, that's even more painful. So what Mark's going to talk to you about today a little bit is a tool that we developed at Schwegman and been using, which, we can take these patents that are relevant and then we can reduce them down to FTO maps that are have a high fidelity. In other words, they're very true to the scope of the patents, so that you don't have to worry about, our map being misrepresentative of the scope of the patent in any way, but allows the engineering people to get right to the nub of what these patents really distinguish themselves on, and also do it in an interactive format, which is easy to repeat if you need to at very low levels. So you take something that might take, 2 hours and reduce it down to 10 minutes or 15 minutes. So repeating it is less tedious and a lot less expensive. Go ahead, Mark, and take it from there.
Oh, thank you, Steve. And I see a question came in too that I probably should answer before I jump into this, if you don't mind. So we've been asked what amount of time we allow ourselves to spend on these searches to avoid boiling the ocean but still capture relevant patents. It's actually pretty quick. Once you sit down with your team and you agree on the glossary that you're going to work through, you can spend less than 5 hours, I would say, is about the max I've ever spent on one kind of upfront search, reviewing the matters and getting them filtered down. I mean, it goes pretty quick, especially if you have friends and relatives in the tech team that are supporting you and helping you understand, the things that you don't immediately have. The patent attorney is always going to be the most ignorant person in the room, and the more you bond with your engineer and scientist, the better off you are. So talking about the way we think about FTO mapping here, first of all, I want to acknowledge Steve Lundberg as one of the primary thought leaders behind this tool. It's been in and around for quite a while, but one of the things that we like to do around FTOs is to, for a number of reasons, including, being able to have more than one person working on the FTO map, is to figure out common items, common elements that are in claims as we're finding these things to map through. So what we try to do is break the patents apart either into fragments or meta concepts that identify key items that an engineer can look at and go, yeah, we do that, or yeah, we don't do that. So let's jump to the next page here, and we'll kind of talk through that a little bit about claim abstraction. So let's build this all out if you could. Realize I had a build on it. So basically, claim abstraction. If most of you, I'm assuming, are lawyers on this call. If you've ever been at Westlaw and looked at the key number system and that sort of stuff, really what we're doing is we're taking claims that have a common process and common thought. So an FTO, theoretically, most of the patents you're looking at should have at least a commonality to a feature or commonality to a concept that you're trying to either avoid or design around. So one of the things we like to do is we're going through this, and when I talk about harvesting the glossary and harvesting the thesaurus of terms, is finding a way to quickly group and eliminate patents that you don't have to pay any more attention to after the fact. So always like to use the chair example. So if you are doing an FTO on chairs, and your chair has fewer than 4 legs and it doesn't have a back, then you want to abstract the concept of the claims that claim a chair that has a back and has at least 4 legs. So by abstracting across your claims to that basic notion, you can then start to rapidly exclude items from review. You don't have to pay, if they're not there, you don't have to pay attention anymore. Also, you can then put your claims into an organized ontology or taxonomy as well. So this is another way to tackle very complex FTOs, to break your invention or your new product into its piece parts. And then that claims that talk about an input, you can color code them in a certain way. You can put those in front of the engineering team and have them just answer that question quickly. So you can attack it in bites and pieces by using claim abstraction. Next slide, please. So this is the pile that Steve was talking about. So in many cases in other law firms, you're going to see a great number of people just reading through patents. You start at the top of the stack, you work your way through, and you write your opinion on whether or not your FTO is clear or not. By knocking out and abstracting claims and mapping them in a concept basic, and you draw those parallels to the features of the product you're designing, you can actually preserve and also move the workload back into one. You have one segment of heavy lifting, but then once you've captured these basic concepts, you can keep adding patents, in priority, that come up and make themselves apparent even after the first pass of the FTO. You can quickly map them, and these types of mappings actually help design teams work. You can give them different names, like call the attorney map. So you give them a bunch of concepts. If you're going to use any of these concepts, call the attorney. Or here's what you've already invented. Don't submit an invention disclosure on again on this concept because we've already patented it to our heart's content. So one of the ways we approach mapping is we really want to organize our thoughts in a logical format that allows our team members and we may have 4 or 5 attorneys working on the same abstraction, so that one gets hit by a bus, that we can step in and understand where they left it off and keep that mapping there. So we're not losing all this knowledge in any one person. So this is the concept. And I think after many of these, I think it works quite well. Next slide. So this is really kind of reinforcing this. So for those who looked at the head notes that and used them as they were doing their searching in their early days of law school, that's really what we're trying to do here. And so just how do we abstract things? We abstract them at various level of buckets. So at the very highest level, it may be a bucket that talks about an input feature, everything around an input feature, everything around an output feature, a particular UI aspect. So you want to look at this in about 3 different levels. The next level down would be concepts in the scopes, the claims themselves that we call scope concepts, that really identify where the points of novelty are in that claim. And then at the very bottom level, we look at keywords, and the primary use of keywords is to look for the synonyms and to start to develop your abstract language that you use, that your competitor may use, and as you're entering a marketplace, maybe you want to use that glossary to write your own patents in, so that you, if the day comes for assertion, you have the glossary that looks very similar to the competitor's glossary that you have priority on. Next slide. So we use an Excel spreadsheet. It's usable by anybody. We embed the all elements rule for infringement. So as we said there, if you can knock it out as early as possible, if your engineering team says, no, we're not going to use it, you can eliminate that patent. You can, in fact, eliminate many, many patents. I mean, a lot of our FTOs may stop at this mapping phase if we've knocked everything out. And then we're able to save the client a fair amount of money in this. But one of the things we do try to reinforce is that this is a tool that we'd like to use evergreen-wise, so that once you've mapped a new product out, and as new patents issue, and you're never able to get all the patents the first time through, because of course the 18-month secrecy rule. So we do try to suggest to our clients that we do use these FTO maps, and we update them either on a quarterly or annual basis, depending on how thick the prior art is and how frequently things issue. So let's jump ahead here. I realize we're running out of time, so I'll charge you. So this is a mapping format. Basically the highlights here is these are each individual patents with independent claims mapped out. As you can see, the dark blue in this would represent an element of language that's held in the claim, whether it's a scope concept or something otherwise. What we try to do here is, this is a tool that we like to work with interactively, so that when we present this to a team member who is not an attorney, we're able to go through just the column A concepts and quickly identify whether you do it or don't. And we color code those. If they don't do it, it's green. If they do it, it's red. And if you might do it, might do it in the future, it's yellow.
Hey,
So,
Mark,
yeah, go ahead.
I would just interrupt. One thing that's really helpful with this mapping tool that we do is, you can see that first patent that's represented there with the lighter blue coloring in the columns that are, I don't know, it's about the 4th column through the 10th column. All of the claims contain essentially the same limitations, except for one claim has one limitation different. So one of the powers of this mapping is that by being able to present a map to the customer and says, okay, if you don't have this element, we can tell you right now, all these claims contain this element. That work's been done before we actually show up. And then you can quickly say, I don't use it. The whole patent goes away, move to the next one. So part of the power of this is really getting these patents boiled down to what's really unique about them. And in this case, there's really only 2 claims in this patent, this first one, because all the claims contain all the same limitations except for one claim. So you really have 2 claims that you're looking at.
That's right. That's right. Thank you, Steve.
Yeah.
And so this mapping format works for a number of things. It works for clearance work. It works for disclosure. Looking for white mapping. What's white space mapping, which we'll talk in the next seminar. But this metaphor of mapping and finding what you have versus what's disclosed versus what's claimed, we find it very, very powerful. It's complex, and what we try to do is, when we sit down with the engineering team, we show them only a small part of this, and we work through what is relatively simple to understand versus being complex, given all this. But there's a lot of information here, and there's a lot of ability to talk to, and these are very, very effective maps. Also, when you've been approached by an assertion to put their map patents up there, and it's a great example of taking the wind out of somebody's sails when they show up with their claim map and you show up with this claim map. So
I want to give Sunil a chance, because Sunil's used these maps a lot, as Tyler's used them too. But Sunil has a way of explaining this that's pretty helpful sometimes.
Well, I mean, just to tell you what you're looking at, that column A in the spreadsheet is a list of scope concepts. And that is basically what an attorney has abstracted the claims into. And so when we show up and sit down with the design team and we're running down through these scope concepts, I'll just tell you that there's a palpably different reaction that you get from those engineers than you do if you walk in with the stack of patents. now what we've distilled this down from, claim language can be very difficult for engineers and even patent attorneys to read and understand. We've abstracted it into things that an engineer can actually understand. And this spreadsheet actually includes links to actual claims and actual claim language. So if you need to dive down deeper than the abstracted version into the actual claim language and to perform some kind of a claim construction, all that information is available there. And we typically have PDFs of the patents too, if we really need to look at figures and that sort of thing. But if you consider the spreadsheet as a whole, it's just a really nice information management tool. And one of the problems with these, with the FTO process is that it's a lot of information to manage. And it's a lot of information that you're getting back from the engineers as to, why these particular scope concepts are things that, there's a key down in the lower right, why those scope concepts might be something that's of current interest for their current design. It might be of future interest for their future designs, or not of interest at all in any design that they might ever contemplate. So we can really just ask them, questions, on a concept by concept basis in column A. Hey, do you guys need this now? Do you need it in the future, or do you never need it? Based on their answer of the questions, we basically are encoding that into column B. And then there's this sort of horizontal multicolored column that you see. And, those things actually change the colors of those actually change in response to the answers that the engineers are giving. So you can basically see that, based on one common concept that might not be needed, multiple claims in a single patent or across a whole corpus of patents can actually be cleared with one answer. And then there's the opportunity to document it too into the spreadsheet, which I think really becomes important in terms of providing some value. I mean, did you do a good and reasonable effort to avoid patents? We have a really nice tool that helps us manage all that information in a way that the engineers seem to really grasp and appreciate. And as a patent attorney, it's really difficult to not have a tool like this in order to organize and collect all the information and then be able to go back to it later on, should you need to.
Thanks, Neil. Tyler, do you have any comments as we get close to wrapping up in a few minutes?
Oh, I maybe just real quick, tapping onto what both Neil and Mark said. I mean, with this being iterative, you can go through this with one product design, and then a year later when you're changing the product, you may have one of these scoped concepts on the left here wasn't in your first product, and that was a reason you cleared patents, and you change that to, hey, I'm using this scope concept now in my product, and this will quickly tell you which patents now are at issue. So it's really, really good for that purpose when you're doing design iteration. And then the other thing I would say is I've also used this tool. I've broken it down. So let's say I'm looking at a drug-eluting balloon catheter. You run, you can look at the balloon, you can look at the catheter, you can look at the handle, you can look at the type of drug, and you can do a map for each of those. And then sometimes in the future, you don't change one of those components, but maybe you change another. You just need to go look at the map and revisit that map. So that's a really powerful tool. And if anyone's hasn't kind of seen this, it's really once you get into it, it's really nice to use.
Thanks, Tyler. So we'll flip to our last couple slides. Actually, let's go to our, I think, next one. This is just some pitfalls and tricks, and I think we'll just, because we're running out of time, we'll kind of pass over this one. This is sort of a key takeaway slide. I think what you've learned today is that there's a lot of different reasons to do FTOs. There's a lot of benefits to them that aren't necessarily immediately apparent. We didn't talk much about situations where it may be infeasible to do an FTO. And I only mean sometimes referring to if you've got a hugely complex semiconductor product that it may just be, overwhelming to try to drill all the way through it. So there are cases where maybe it's just not feasible, but most of the time, especially if you're just adding new features to a product, it's very easy to do. And if you've got a product that isn't super complex, you can certainly do an FTO. I think it's always worth the effort to do an FTO because the cost versus the benefit is usually quite favorable. And then also, I think for credibility purposes, if you're a startup or a company getting rolling, having checked that box and gotten some feedback. And by the way, you almost always find something you need to worry about at some level when you do an FTO, but having advanced knowledge of that and having a strategy for coping with that is pretty much all anyone expects a company to do to get funding. So I think it's, even if you're going to find some bad news, better to have a story about why the bad news isn't really that bad of news than to be caught with your hand, essentially unawares and look sort of like you're making up excuses after the fact. With that, I think we'll call it a day. And thanks everybody for joining with us again. Obviously, I'll put one last pitch in for the firm. We do a lot of these things, and we're quite proficient at it. So if you do have any work you need to be done in this area, certainly we'd be worth a look. And with that, I'll turn it back to Michelle.
Thanks. Thanks, Steve, and thanks everyone for joining us. Our next patent analytics webinar will take place on June 25th, when we cover using white space maps to identify open spaces in the patent landscape. And we hope to see you then. Thank you everyone for joining us, and be well.
Thank you. Thank you to the panel members too. You guys did a great job. Thank you very much.
Thanks.
Thanks, everyone.
All right, thank you.